Okay, I'm Eric Schnapper. Oh, I think it'd be impossible not to speculate after you walk out of the court about what's going to happen and who's going to write the opinion and how it's going to read. Um, it's difficult to predict. Sometimes you get a pretty good sense, but sometimes you're just dead wrong. And I argued a case I mentioned about reading the word changing clothes. I got um, uh, challenging questions from Justice Ginsburg, and I walked out and concluded I was in trouble. If I didn't have Justice Ginsburg, I was not getting anywhere. Um, on the other hand, the other side was selling a theory that everything you wear is clothes, and Scalia just laughed and said we couldn't say that, we'd be lying. So I figured they were not going to sell that standard. So sometimes you get a sense of that. Sometimes not. My most memorable example was a case I worked on about 20 years ago about whether you could bring a lawsuit against a city council that had passed an ordinance to fire someone by abolishing their job, and there was a technical issue about when you could and couldn't sue. But in the middle of the oral argument, Justice O'Connor said, when I was in the Arizona legislature, we fired people all the time by abolishing their jobs. And I thought, this isn't going to end well. So you occasionally have moments like that. But typically there are aggressive questions of both sides, and if you remember the aggressive questions to the other side, it's encouraging. If you remember the aggressive questions to yourself, it's not. It is hard to predict. There are some issues that by their very nature will come up repeatedly. Searches, First Amendment cases where you've got to balance competing interests, and the court builds from case to case, and you'll have individual justices who've written opinions for themselves or for the court over the years, and so you'll certainly, the jurisprudence can loom larger. Each case builds on the rest, and the court wants to be consistent with what it's done before, although it's typically in an area that's somewhat new. There are also areas where the court is just active. It keeps taking cases for whatever reason. We just theorize that they're interested in something. So there was a period when they took a lot of counsel fee cases. And the period they took a lot of cases about searching car trunks. And there, although it wasn't necessarily something that came up a lot and was important, the court was just interested in it, which is a perfectly understandable phenomenon. The cases I work on just don't typically fall into either of those categories. And they're typically issues of statutory construction, and they don't relate all that much to anything that's come before. Occasionally, you'll see that. The court granted a cert today in a pair of cases about whether certain time limitations are jurisdictional. Now, the court's written about that in half a dozen cases in the last 10 years, one of them mine, and so we'll be building on that case law. I don't think it's been all that individualized. The court has been giving pretty consistent answers to it, but at the least I'll remember who wrote which opinion. I mean, you've been through a lot of these things, and you develop instincts about how to make arguments. You know, at some point, you'll be in the middle of writing a brief and talking with a lawyer on your side, and you'll go, this argument just isn't going to work, we shouldn't make it, and you have a conversation, you might explain it for a few minutes, but you develop an instinct about what will work and what will not work. You develop a sense about, you have some just gut reaction to how to do things at oral argument. You maybe remember something you did before, or maybe do it again, not remembering you did it before. But I would not describe it as a deliberate process. It's just you just do it a lot, and you have a sense about how to do things. But I can't call to mind a case in which I thought, oh, I had this problem before, and I know what worked. Georgetown has a terrific program of moots, and I sign up for that in every case. If I get it, I'm thrilled. Public Citizen also does moots, and they're excellent. I will always do a moot. The moots are, if they're good, they're long and they're ugly, and they're much harder than the actual argument. And you get a sense of what questions you don't have good answers for, you get a sense of what questions are going to bother people the most. You know, my actual argument typically looks very different from the moot. And I talked to Dory Bernstein, one of the people at Georgetown that works on this, and one of the things she commented upon was there are people who use the moots, learn things from them, and make, you know, and argue differently, and there are people for whom this seems to have no effect at all. They come in and make the same arguments whether they worked or not. But I don't. You know, I find the moot, you know, scares the bejesus out of me, and then I do things very differently. Usually, how I start is going to be different, and you know, usually the answers I had to the hardest questions didn't work, and I'll redo that. So I find them absolutely invaluable. I only do one, but if I were working with a lawyer who hadn't done it before, I would definitely make them do two. Well, I think they're better at that than I am. I think, you know, I'm successful in anticipating some of them. Obviously, guess wrong a lot because I'll prepare for 100 questions to get 5 or 10. You know, there are I'm sure always questions that I didn't see coming. I mean, Solicitor General has this extraordinary asset of all this institutional memory and experience, and so when they do a moot, they've got 10 people sitting around who collectively have been through 100 oral arguments, and they've read the briefs cold, and they've come in and said, well, this is what strikes me. I suspect if I could do a moot in the SG's office, I would be better at this, but I certainly I don't have that batting average, and that's one of the reasons why you know, I worry about when I work on a case with a lawyer who has done it before and wants to argue it, because I know there will be questions that we haven't anticipated, and I've seen whole arguments go down the tubes because of that. I can't anticipate everything. Of course, some of the questions you don't anticipate aren't a problem. When I argued a case, I'm talking about the fired fiance, and in the record, the plaintiff and the woman who complained are just engaged, and Scalia, for whatever reason, asked me pointedly whether they were still engaged, and Justice Ginsburg, who read the footnotes, pointed out they were married, and then I was able to note, having met them the day before, that they had a lovely 2-year-old girl. Now, I did not anticipate that question. I would not do that. I would not do that. I think it's. I think you really want the lawyers focused on dealing with the court, and the court focused on the substance of what they're saying. And I think everybody would be the worse off if there was anything else on anybody's mind. If it were up to me, maybe every once in a while, when you have lawyers who could handle it, I'd tape it. I'd record an argument. I think it is the American government at its best. I mean, no disrespect to the other 2 branches of government, but to see the Supreme Court in action, to see 9 people really struggling to understand an issue and think it through is extraordinarily impressive. And I think it's a loss to the country that people don't see that. I think it would be a bad idea to have cameras in the courtroom ordinarily, but I think it would be good for the country if, you know, occasionally or in an inappropriate case where you had lawyers who, you know, weren't going to get distracted in a case that wasn't going to be the wrong case to be doing this because of what the issue was. If the court, you know, had something like I would do a case that wasn't highly technical and wasn't really inflammatory, and you had lawyers who'd done this before and they weren't going to get thrown off by it. I think it would be nice to have one of those out there. But as a general practice, you know, I wouldn't even want it in my cases, and I certainly wouldn't want it in a case that was, you know, something that was a matter of public controversy. I don't think I'd want the Hobby Lobby case on tape, on video. I just think that would not be a good thing. It would be very hard not to be thinking about how this was going to look on television the next day for everybody. And there are, I think some people who've done this repeatedly could put it out of their minds, and if it wasn't a case that because of its substance, everyone would get all excited about it, it would be easier if we were fighting about whether a particular provision was jurisdictional or not. You wouldn't worry about, the pro-jurisdictional people marching in front of your house saying, how could you say Section 12 was jurisdictional? What kind of a human being are you? I just think it would be a bad idea. I think you could do it. I think it would be great for law students to see it. There was an argument last year that was an argument about in personam jurisdiction relating to Pennoyer versus Neff. If you've been to law school, that makes sense. If not, don't worry about it. I think that would be a fine case to have on videotape. I think first-year students would love it. It was non-inflammatory. I know the lawyers involved; they would not have been thrown off by it. But I think it may be like the T-shirt that you get if you sign up for the bar review class, which reads, "Do it once, do it right, and never do it again." I wouldn't even say grandstanding. You just don't want to be thinking about how something will sound to anybody but the 9 justices in front of you. I just think it's not a good idea. I wouldn't want to even begin to guess. It's so hard for the most experienced lawyer to do this. I think for the non-experienced lawyers, it would be bad. I think it would make it harder to talk lawyers who haven't done it before out of wanting to do it again. Don't do it for the one time in their lives. And I think the court is generally ill-served by people doing this who haven't done it before. My recommendation, if the chief were to drop me a note and ask me, would be to do it once in the right kind of case with the right kind of lawyers, and see what we learn from that. The court deals with many issues, taking small steps and cautiously. That seems to be appropriate here. Yeah. Most of the cases the court hears are not going to go viral if you put them up on the web. No one's going to understand a word about what's going on. I mean, I've gone in there with people who, they'll go there and listen to the argument in the case before, and they'll come out going, I had no idea what was going on there. I come out sometimes saying, I have no idea what was going on there. If you hadn't read the briefs, you'll get in there and the chief will say, well, what about this argument, footnote 12 in your brief about, the ad damnum clause and the statute of fraud? And how much good will it do to the country to see that? A lot of people will decide not to go to law school if they do. I say try it once in the right case, see where we come out, but my instinct is not to do more than that.